Hello everybody, welcome to iExamB. Embrace the iExamB learning experience. In this video, we are going to discuss previous year questions from CPC and Limitation Act of the past 3 years. Limitation Act was added last year. Prior to that, there was CPC present in the syllabus. Starting with the first question, where the prescribed period for any suit, appeal or application expires on a day when the court is closed. The suit, appeal or application may be instituted or made the next day, on the day when the court reopens, on the day when the court decides, on the same day next week, on the day when the parties decide. Correct answer is B, on the day when the court reopens. This is given under section number 4 of the Limitation Act, expiry of prescribed period when the court is closed. Question number 2. In computing the period of limitation for any suit, the time during which the defendant has been dash and from the territories outside India under the administration of central government shall be excluded. Option A, time during which the defendant has been absent from the territorial jurisdiction of state government, absent from the territorial jurisdiction of central government, absent from India, absent from the jurisdiction of High Court, undergoing imprisonment. The correct answer here is C, absent from India. This is given under section number 15, subsection 5 of the Limitation Act. In computing the period of limitation for any suit, the time during which the defendant has been absent from India and from the territories outside India under the administration of central government shall be excluded. Question number 3. What is the limitation period for a suit by a mortgagor to enforce payment of money secured by mortgage or otherwise charged upon immovable property? Option A, 3 years when the money sued for becomes due, 2 years when the money sued for becomes due, 1 year, 12 years, 30 years. Correct answer here is D, 12 years when the money sued for becomes due. This is given under Article 62 of the Limitation Act. In the schedule, Article 62 talks about this limitation period. These were the 3 questions that came from Limitation Act, starting with CPC. A decree holder is any person in whose favor a decree has been passed, any person in whose favor an interim relief is granted, any person who is in debt by the decree, any person against whom decree is passed, any person who does not get decree executed. The correct answer here is A, any person in whose favor a decree has been passed. This is given under section number 2, subsection 3 of CPC. Decree holder means any person in whose favor a decree has been passed or an order capable of execution has been made. Question number 2. Which provision deals with mesne profits? Section number 2, subsection 12, section 3 of CPC, section 2, subsection 14 of CPC, section 2, subsection 6 of CPC, section 10 of Indian Contract Act. The correct answer here is 1. Section 2, subsection 12 of CPC defines mesne profit. Mesne profits of the property means those profits which the person in wrongful possession of such property actually received or might with ordinary diligence have received, together with interest on such profits, but shall not include profits due to improvements made by the person in wrongful possession. Question number 3. A residing in Delhi publishes in Calcutta statements defamatory of B residing in Mumbai. B may sue A only in Delhi, only in Mumbai, either in Mumbai or in Calcutta, either in Delhi or in Calcutta, only in Calcutta. The correct answer here is D, either in Delhi or in Calcutta. This is given under section number 19 of CPC. Suit for compensation for wrongs to persons or movables. Where a suit is for compensation for wrong done to a person or to movable property, if the wrong was done within the local limits of jurisdiction of one court and the defendant resides or carries on business or personally works for gain within the local limits of jurisdiction of another court, the suit may be instituted at the option of plaintiff in either of the said courts. This is an illustration of section 19 of CPC. Question number 4. The court may compel attendance of any person to whom a summon has been issued. For this purpose, a maximum fine can be imposed to the tune of any of these. The correct answer is option A. As per CPC, the maximum fine that can be imposed is Rs 5,000. This is given under section number 32, penalty for default. The court may compel the attendance of any person to whom a summon has been issued under section 30 and for that purpose may issue a warrant for his arrest, attach and sell his property, impose a fine upon him not exceeding 5,000 rupees, order him to furnish security for his appearance and in default commit him to civil prison. Question number 5. If judgment debtor obstructs delivery of possession of property, which of the following action the court can take? Court can order detention of the judgment debtor. Court can make an order for detention of judgment debtor at the instance of decree holder. Decree holder has to make application for arrest of judgment debtor. A and B, any of the above. The correct answer here is B. Court can make order for detention of judgment debtor at the instance of decree holder. This is as per section number 51 of CPC, power of court to enforce execution. Question number 6. Where immovable property is sold in execution of a decree and such sale has become absolute, the property shall be deemed to have vested in the purchaser from the time when the property is sold, when sale becomes absolute, when actual transfer of property takes place, when decree is made, when decree is executed. Correct answer here is E, when property is sold. This is as per section number 65 of CPC, where immovable property is sold in execution of a decree and such sale has become absolute. The property shall be deemed to have vested in the purchaser from the time when the property is sold and not from the time when the sale becomes absolute. Question number 7. What can a civil court do in case resistance is caused to execution of a decree by judgment debtor? Option A. Order that decree holder be put in possession of the property. Order civil prison of 60 days maximum to judgment debtor. Order civil prison of 30 days. E or B, E or C. Correct answer here is E, E or C. Civil court can order decree holder be put in possession of the property and order civil prison of 30 days to the judgment debtor. This is as per section number 74 of CPC, where the court is satisfied that the holder of a decree for the possession of immovable property or that the purchaser of immovable property sold in execution of decree has been resisted or obstructed in obtaining possession of the property by the judgment debtor or some person on his behalf, and that such resistance or obstruction was without any just cause, then the court may, at the instance of decree holder or purchaser, order the judgment debtor or such other person to be detained in civil prison for a term which may extend to 30 days, and may direct that the decree holder or purchaser be put in possession of that property. Question number 8. Impleading an unnecessary party to a suit is non-jointer of parties, misjoinder, jointer of necessary parties, jointer of parties, jointer of proper parties. Correct answer here is B, misjoinder of parties. Misjoinder of parties means a jointer of a party who ought not to have been joined either as a plaintiff or as a defendant. In other words, it refers to impleading an unnecessary party. It may also refer to a situation in which a plaintiff is impleaded as a defendant and vice versa. This is covered under Order 1 of CPC. Question number 9. Every suit shall be instituted by presenting plaint in duplicate to the court or such officer as it appoints on his behalf. Plaint to the court or such officer as it appoints in this behalf. Plaint to the court, plaint in duplicate to the court, plaint to the court and the defendant. Correct answer here is A, plaint in duplicate to the court or such officer as it appoints in this behalf. This is given under Order 4 Rule 1 of CPC, suit to be commenced by the plaint. Every suit shall be instituted by presenting plaint in duplicate to the court or such officer as it appoints in this behalf. Every plaint shall comply with the rules contained in Order 6 and 7. The plaint shall not be deemed to be duly instituted unless it complies with the requirements. Question number 10. As per Order 7 Rule 11 of CPC, what happens when cause of action is not disclosed by the plaint? Rejection of the plaint, dismissal, ex parte decision, relief is granted, plaint is returned to submit again. Correct answer here is A, rejection of the plaint. As per Order 7 Rule 11, the plaint shall be rejected in the following cases: where it does not disclose a cause of action, where the relief claimed is undervalued, where the relief claimed is properly valued but the plaint is returned upon paper insufficiently stamped and the plaintiff, on being required by the court to supply the requisite stamp paper within a time to be fixed by the court, fails to do so, or where the suit appears from the statement in the plaint to be barred by any law, where it is not filed in duplicate, where the plaintiff fails to comply with the provisions of Rule 9. Question number 11. When a counterclaim is set up in a suit, what happens to the counterclaim if the suit is dismissed? Counterclaim will be dismissed. Counterclaim can be proceeded with. A new suit can be presented for counterclaim. Court directs the counterclaim to be freshly instituted. Counterclaim is stayed. The correct answer is option B. Counterclaim can be proceeded with. This is given under Order 8 Rule 60, effect of discontinuance of suit. If in any case in which the defendant sets up a counterclaim, the suit of the plaintiff is stayed, discontinued or dismissed, the counterclaim may nevertheless be proceeded with. So these were all the questions that came from CPC. If you need any form of guidance, any form of preparation material to prepare for SEBI legal exam, you can check out our SEBI legal online course. In 2023, 12 of our course users got selected as SEBI legal officers, and we have been guiding and helping students to achieve their dream of SEBI legal over the past 3 years. So check out our course if you need any form of preparation material, mock test, guidance, etc. We at iExamB help you prepare 50% faster with a crisp and concise content. Subscribe to our channel. Stay tuned. Thank you.